Hi, I'm Kirk Evans, president of U.S. LawShield. We're here today to talk about a recent ruling out of the U.S. Supreme Court. So, got to give you a little background first as to why this is important. So, we're going to go with some background first, and then what the U.S. Supreme Court did, and then how this may impact folks down the road. So, a little background. Across the country, since the Supreme Court's Brune decision in 2022, there have been a number of cases challenging the constitutionality of regulations on firearms. So there have been challenges about sensitive places, prohibited persons, but a big one is 18 to 20-year-old people either purchasing, possessing, carrying, or getting permits to carry firearms. And a number of courts all around the country have ruled that it's unconstitutional to prohibit 18 to 20-year-olds from either possessing, carrying, purchasing, or getting a permit to do one of those things around the country. The courts have been on both sides of this, but there have been a number that said it's unconstitutional to prohibit the 18 to 20-year-olds from having a firearm. So what is this case about? In Pennsylvania, the way their laws are put together through a series of laws, they decided that during an emergency, it was against the law for an 18 to 20-year-old to carry a firearm during a declared state of emergency. So you may say, what's the big deal here? This sounds like a really narrow issue. Well, as many states had, Pennsylvania had about a 3-year period of declared state of emergencies due to COVID. And so the effect was that 18 to 20-year-olds couldn't get a permit and could not carry firearms. This law was challenged, and the Third Circuit Court of Appeals federal court held that it was unconstitutional to prohibit the 18 to 20-year-olds from carrying a firearm openly during a declared state of emergency. So, what did the court do? What did the U.S. Supreme Court do? The U.S. Supreme Court vacated that decision, meaning, at least as we sit here today, that decision does not exist, and it is constitutional, permitted, for Pennsylvania to prohibit 18 to 20-year-olds from carrying a firearm during a state of emergency. So did the Supreme Court explain why, explain their reasoning for their ruling, give us any hint as to what they were making this decision for? The Supreme Court did not. Normally they give like 70-page opinions or 20-page opinions, and they're very clear. Or even if they're not clear, they provide a lengthy explanation for the lawyers to pore over. Here they did not. They gave us a one-paragraph blurb that said, "Decisions vacated. Please have further proceedings in light of our decision in Rahimi." So what is Rahimi? For the folks who are not familiar with the Rahimi decision, that is a recent Supreme Court decision on prohibited persons. The Rahimi decision said that states or the federal government can preclude domestic violence, persons accused or convicted of domestic violence from possessing firearms. The Supreme Court said you can preclude folks who are a danger to others from having firearms, but you can't preclude someone simply because they are not responsible. So what do we know now? The Supreme Court was obviously sending some type of message to us out there. We don't know. There's no way to know right now until this goes back down, their further rulings comes back up to the U.S. Supreme Court, and even then the Supreme Court may not accept or rule on that decision. So we're left to take a guess as to what does this mean. Was the U.S. Supreme Court just really, really interested in this specific issue about 18 to 20-year-olds in a declared state of emergency? Maybe that's what they're talking about here. Or are they saying this whole issue of 18 to 20-year-olds possessing or purchasing firearms, that we're going to let the states actually regulate that as opposed to it being unconstitutional? Could be what the Supreme Court was signaling. Or is the Supreme Court signaling, just as a blanket matter, we're going to give the states a lot more leeway to regulate firearms than these courts thought that they would? So do we know? We do not know. It may be months, if not years. In fact, it could be never till we figure out what the U.S. Supreme Court says on this specific ruling. So what does this mean for individuals around the U.S. Who might be carrying based upon a ruling in their state or jurisdiction that said that a certain bar or a certain law was unconstitutional? As of right now, the only thing we know for certain at this moment is if you're 18 to 20-year-old and there's a declared state of emergency in Pennsylvania, you cannot openly carry a firearm. If there's a declared state of emergency, you must have a permit in Pennsylvania. Otherwise, you cannot carry a firearm in public. Even that, though, is going to be subject to further proceedings. So do we know if this decision impacts all these other cases all around the country? We don't. Some of them are final. Some of those decisions are final with no right of appeal, to where they're essentially over. But I would not, take that as the final answer. I guarantee you, in some unfriendly jurisdictions, that anti-gun prosecutor, law enforcement, district attorney is going to decide that this case means that all of these rulings on 18 to 20-year-olds are out the window, and that the court has signaled that it is permissible to regulate 18 to 20-year-olds and the possession or purchasing or giving permits to or carrying outside the home, that is now permissible. And so, for example, if you are in a state where you've had a ruling that says 18 to 20-year-olds can carry, and that decision is final, so you've been carrying a firearm around in public, you may have an anti-gun prosecutor say, nope, Supreme Court has now made its position clear. I'm going to charge you, arrest you, but maybe even convict you, at which point you might have a right to appeal and make these arguments. But that's how serious it is. So for 18 to 20-year-olds who've been relying on one of these recent decisions, you may find an anti-gun prosecutor, anti-gun district attorney, or someone in law enforcement who doesn't like members of the public carrying firearms who decide, hey, that Supreme Court ruling means that the tide has turned on this issue and 18 to 20-year-olds can be regulated, and you may find yourself charged, even convicted, even put in jail or prison while you're waiting around for your appeal to be held on this issue. So we need to be very, very careful. If you're a U.S. LawShield member, feel free to call in at no additional cost to you, and you can ask to speak to the independent program attorney in your state, and they can help walk you through the ins and outs of, whether you're 18 to 20-year-old or you have kids or grandchildren who are either carrying, looking to purchase, or have firearms, and they can help walk you through what the law is and what you need to do to stay safe, stay on the right side of the law. Until then, until we get further rulings out of the Third Circuit, Pennsylvania, maybe back up to the Supreme Court, we do not have any certainty on this issue. So stay tuned for further developments, and thank you for watching this video.